Hello, hello, hello. It's Attorney Mike Griffin coming to you from Chicago as usual, and I've got a hot update. I did a video and I just put together a playlist. Link in the description below. I called it I might have to work on the title, but for the time being, it's called Sovereign Citizen, Divorce and Child Support. This is a case I didn't realize because I was looking for the videos. It's a couple years ago, and he comes in. And his eyes are closed through most of the hearing, and he pulls his SovCit nonsense. And the other video I found is actually interviewed the wife about this. Meanwhile, there are a whole bunch of other videos which I couldn't find before I started the stream, but they're out there, were updates of him basically being a deadbeat and not paying anything. And he continuously tries this. I paid for things with my magic trust. Well, today he is in court on a possession charge, and he pulls the old I've already paid for this with my magic trust routine. Again, let's do it, shall we?
28 Circuit Court here in Missaukee County. Our first case this morning is People versus David Thompson. This is file number 25-1379-FH. Mr. Thompson, you can come and take a seat. I don't know which attorneys handle that. So.
We are David Denhout on behalf of the people.
Court recognizes the defendant, Mr. David Glenn Thompson, who is now at the defense table, and he is currently representing himself in this file. Mr. Thompson, as you might recall, I just need to go over a few things the law requires me every time. Do you understand that you have the right to hire your own attorney?
That is correct.
And you understand that you have the right to have the court appoint an attorney to assist you if you cannot otherwise afford it?
That is correct.
And you'll also have the right to self-represent pursuant to the Constitution. You understand?
That is correct.
And you are electing to represent yourself. Is that correct, sir?
I am, Your Honor. Yes.
And I think you've represented yourself in this file the entire time.
Yes.
And through district court. Okay. All right. So we're here today for two things. The first is we're here today for a pretrial conference. The pretrial hearing today is just to find out where the case is going. The case probably, yes, just recently bound over to the circuit court after going through the preliminary exam phase in the district court. And I see that the felony information was filed on February 6th. And the court then subsequently issued, that's whom I did. Yes, a scheduling order. Or about, actually, that was done on February 5th. It looks like the information was dated February 5th, but filed on the 6th. We're here again today for a pretrial conference hearing. Mr. Thompson, the only thing we do at a pretrial conference hearing is just to find out where the case is going. If there is a resolution of any kind, you guys can tell me. If not, then I'm going to ask if there are I'm going to ask a couple other questions. The first thing here is, see that the defendant is pending charges, and I didn't say what they were. Looks like there are 2 counts for a possession of a controlled substance. All right. Mr. Thompson, is there any resolution between this case, in this case, as far as you know?
Your Honor, I believe there is.
Okay. Well, hold on. I just got to ask the other party first, because a resolution means an agreement. Mr. Denhoughton, are you aware of any pretrial agreement?
I'm aware of that.
All right, thank you. That just lets me know that I've checked off that blank. What do you think is the nature of the resolution then?
Your Honor, I made a deposit with an ex parte hearing regarding another matter, equity taking jurisdiction to avoid a multiplicity of suits, putting up consideration for full accord and satisfaction. and settlement and closure. To my knowledge, from what I understand, it includes all matters and all liabilities related. Now, I did realize that I should have directed the clerk to deposit that in accordance with the Judicature Act revised in 1961, Act 236 under Section 600.
Which is number one, wrong.
.576, depositing funds, stocks, or securities with the court clerk pursuant to court order is discharged from further liability. And in that matter, I was the payer, so I did that. And I'm still trying to make sure all of this gets settled and closure in honor.
Oh, okay.
That would be another one of those envelopes that you.
Yeah, I understand. Okay.
If there's any other instructions or my duty that I'm aware of, but I'm willing to correct my mistakes.
Okay. Let's take a quick look here.
First, he announces to the judge that we have a deal, and then the prosecutor, I can't really hear him, but he must have indicated, no, we don't, or we wouldn't be here. And then his deal is, I've paid a fine. Well, you haven't been convicted and you don't have a fine, but he's saying I've paid a fine unilaterally resolving my own case without the prosecutor involved. Yeah, you see, that's not how this works.
And you were giving me a reference to the Judicature Act, and I know it's 600, and you referenced
576, Your Honor.
Okay. And how do you think deposit? What did specifically again? Did you deposit
A certificate of security?
Okay. And so, what security was it that you?
A certificate of security, i.e., nothing. Complete made up nonsense.
Tendered?
That was consideration
Or
any outstanding liabilities, Your Honor.
okay. So your deposit of this certificate of security applies to how much was it for?
That it has been unassessed and unknown at this time, which is what I'm seeking further from the court assistance. In
All right. So, and you think that somehow takes care of this particular file?
due to the fact that where there's a conflict and variation in the law between common law and equity, Your Honor, equity shall prevail, and equity takes multiple jurisdiction to avoid a multiplicity of suits.
All right. So are you charged with the possession of controlled substances in more than one case?
No, Your Honor, that case, I was a payer, which falls into this with the 600-576. And to my knowledge, a trust running in the background deserves to be heard in equity.
So in this particular file, there isn't, you don't owe anything.
My knowledge, I do not. I have
No. So
to
then
my knowledge, I'm free and clear of liability, Your Honor.
No. Liability is a different word. Liability doesn't apply here yet, right? There's no piece, there's no judgment that says you owe anybody money. So there's no liability.
Thank you for correcting me.
Yeah. Now, the question here is there a resolution to the case? Filing whatever you think you filed doesn't resolve this particular case.
I understand, Your Honor.
Okay.
In equity, I thought that they took jurisdiction to avoid multiplicity of suits.
Okay, that being no.
Multiplicity is something different. Multiplicity is generally used if you've been charged with the same act more than once, or if you've been tried more than once, then that becomes double jeopardy. Multiplicity is something entirely different. Unless you're telling me you've been convicted of the same offense already before, which I know the answer is no.
I have not.
It's okay. So, I'm sorry, sir, I cut you off.
I do have evidence that I did deposit with the prosecutor's office of potential resolution.
Okay, so you made an offer to the prosecutor to resolve the case?
Yes, Your Honor, and I've got the
Okay.
card recent.
That's okay. And so what happens here is I'm just the manager of this small version of Tiger Stadium. I always use Tiger Stadium. By the way, I don't even watch baseball. But anyways, this is my little Tiger Stadium. All I need to know is that somewhere in the future, and the date is currently on a piece of paper, looks like that is May 8th, May 6th. May 6th, we've got a game. It is the Tigers. That's his home stadium, so we'll say that's Mr. Denhound versus the Twins. That's Mr. By the way, I like Minnesota. That's fine. But all I need to know is, are we playing baseball on May 6th? If the answer is either yes or no, we're going to get 2 bites of that apple. Today's the first.
This judge loves his baseball analogy. He used it in a prior hearing, which I can't find. By the way, if anyone wants to help me, tell me the clips I'm missing for the playlist. But he used this baseball analogy last time, which is fine. It's appropriate. It's simple. It's G-rated. But he just loves to act like his courtroom is a mini Tiger Stadium for some reason.
First one. The second one comes at the final pretrial conference. So today, do I keep the game currently scheduled, People versus Thompson, set for May 6th? That is all I'm here to do. Now, if you and Mr. Thompson or Mr. Denhouten reach an agreement, that's between you guys. I don't care what you guys deal with right outside. There's nothing to do with me. Mr. Denhouten says they don't have an agreement, which means your offer has been, at least at this point in time, rejected. So now the next question here is, so that means we don't have a resolution today. I don't know.
Here's a translation for you, SovCit. The prosecutor doesn't consent.
I don't understand necessarily the theory of Mr. Thompson resting on the statute that he referred to. This has nothing to do with liability, but so far, it doesn't end the case. You can't pay off a fine until I order a fine.
You lose because sports ball.
So, therefore, the next question I have is, and I know that Mr. Thompson is currently on bond, so we don't have any issues there right now yet. I know there's a bond petition.
Law.
The next question here is, have you gotten all the evidence, the discovery in the case, like the police report, any body?
I'm not sure.
Yeah,
Sorry,
it's okay. It's okay.
I'm not sure that I have it in total.
All right. So the best thing you can do is you can look at the police report, and if, for instance, it says, well, hold on. Have you received a copy of the police report?
I believe I do have one, Your Honor.
Have you received, it should be a lab report from the Department of State Police, a forensic crime lab?
I'm not sure if I've got that yet.
Mr. Denhouten, has there been a crime lab report yet? Sometimes they're running behind. Nothing works like it does on television.
Your Honor, it has been submitted, but I don't believe we have a copy of it.
All right, so that means I turn over here, and I'm just going to say on my discovery issue, still.
Your Honor, I stand corrected. I do have a copy.
Never mind. I don't have to write that down. The next is was there a prelim?
There was, Your Honor.
Okay. Let's make sure that I ordered the prelim transcript.
January 3rd.
All right. Thank you. Let me take a quick look here.
There is audio and video that has been submitted as well.
Okay.
He doesn't have a copy. I'm happy to send another copy.
All right. So I see that the transcript has been ordered by my office. The transcript of the prelim will be prepared and issued to both the prosecutor and to the defendant. Now, the next question would be, I'm sorry, if you have received those. You say you think you have, so I'm just going to tell you what you can do is look at the police report. And typically on the last page or two, it will report whatever exhibits they may have collected. Let's say, for example, this was well, I don't use an example, let's just use the charges. If there was some kind of baggie, that will be put into evidence. That'll be listed on there. You don't get the baggie. You'll get the test of that baggie. Now, you should also be able to get the chain of custody, which should generally come. So you just want to make sure that there's the chain of custody. Now, if the defense chooses ever.
Seriously, I don't know why we're giving a legal clinic to him. It doesn't matter. The prosecutor's going to do these things anyway, and he's not going to know how to deal with it. But I don't know why we're giving him this level of specificity.
To have a substance retested, it can ask for that, but it pays for it on, you would pay
I like this judge, but he's bending over backwards for him.
for it on your own. You'd have to find a lab, and then you'd have to come and have me give an order that says, hey, police agency, send it to that lab. So things like that. So you can ask questions about discovery. But so far right now, it seems like you have it. But again, if you look at that police report, look at the last 2 pages, it will list all the exhibits, and you're going to want to make sure you've got those exhibits. And typically there's some kind of body camera. Now, by the way, unlike what they show on television, not every body camera works all the time. Not every body camera gets digitally downloaded for some reason. I don't know why, but you just can find out that information. And sometimes, by the way, they're muffled. Good luck figuring that out. All right. So we don't have a resolution. We don't have any discovery issues. The next question is do we have any motions?
Good luck figuring that out is the judge nicely saying, I am confident that you won't.
Now, Mr. Thompson, inside my schedule order, I said, if you have any motions, such as a motion to suppress, you can raise it within 30 days of the transcript. So if the transcript gets provided to you, and let's just say for a random choice, March 15th, you have until April 15th to raise a motion, like a motion to suppress. Okay. Now that I've covered all that, now let's turn to this last question here. The next question here is, Mr. Thompson, looks like on February 19th, the prosecutor filed a petition asking to show cause. Now, basically alleging that there was some kind of bond violation. Particularly in this instance, the bond violation is that you allegedly failed to appear for a drug test on February 9th of 2025, and then February 16th, 2025. Now, the prosecutor could have asked for a bench warrant. He didn't do so, which is pretty common in this kind of a situation. I can tell you that either party or the court can ask to review someone's bond, and there isn't a right to a trial. There's no jury. There's no proof beyond a reasonable doubt. It's just that the court looks at it and gets to determine whether or not that's a violation. And then, if so, what should I do? Should I revoke bond? Should I remand the defendant into custody?
Yes, you should. He doesn't, but you should.
Should I modify the bond, or should I just wag my finger if they don't do that again? Now, do we want to have a hearing on that? And do you want to have a hearing? And by the way, well, hold on. Miss Dean Stark joins us today, also via Zoom from the Wexford Misaki Community Corrections Program. Miss Stark, are you here for this one?
Yes.
I just want to ask you this question. Have there been any other alleged violations?
Two violations on the 9th and the 16th for no shows.
All right, but nothing since then?
No.
All right, thank you. All right. Has he shown up at all for any testing?
He has.
All right. Any I assume they've all been negative?
Just positive for THC.
All right. And that probably wasn't listed. Okay. All right. And by the way, Mr. Thompson, if you admit to failing to show up for those 2 tests, I'm just going to go with the finger wag. And say, don't do that again. Make sure you show up. Okay. Is it true you failed to appear for those 2 tests?
By mistake, I did, Your Honor.
Okay.
I apologize on behalf of the court.
As long as you've been going to testing and you've been, and it just was.
That's mildly annoying. He needs to, he should have been revoked right there. In my humble opinion, I know what the judge is thinking, and I do understand it. There's some merit to it. He's thinking, screw that. Let's get this thing to trial and get the conviction on him, because I'm confident that's where we're going, and we can sentence him then.
On a couple different events. I will note they appear to both be on a Sunday. So, I'm just going to say, make sure you don't. The court finds that there's been a bond violation, but the court is not going to revoke, modify the bond. I'm just going to do the finger wag. There we go. All right. Yes, sir. Anything else?
He didn't show up because he was dirty, and he is testing positive for marijuana, which is probably a violation of his bond condition. I don't remember exactly. I think I did the prior hearing, so I could probably find it, but I can't find it. I have too many videos.
I wish to express gratitude, and I appreciate the court in its leniency. And I also want to let the court know that every day of my life is getting better.
I'm glad to hear that, Mr. Thompson.
I appreciate the opportunity to improve.
No problem, and I don't mind discussing the questions you bring up. That is perfectly all right. Mr. Denhouten, anything else today?
No.
And I'm sorry, Mr. Denhouten, I should have let you argue if you wanted me to revoke bond. I failed to do that. That was
I would not have argued against it, Your Honor. As the court notes, I initially requested a show cause.
I got you, and I'm sorry. I expected you to just to say that, and so unfortunately I skipped over you, and that wasn't polite. All right, thank you very much. This case will continue to next be set on the docket for a final pretrial conference. All right, thank you all very much. We are adjourned.
Well, there you have it. But imagine this. I've been following this case for a while. So for once, I have some background. I know what I'm talking about. Well, let's not go that far. Let's not go that far. I have some vague familiarity with what I'm talking about. No, there were no fireworks. You're right, Hector. And the reason why is the judge slapped him down so gently you didn't notice. He goes on, oh, I've got this one. And the judge is like, well, that doesn't do it. So what are we doing? That was the moment. He was sidestepping all these issues. He just wants to get it to trial, which makes some sense. But imagine this guy, in some of the prior hearings, this guy keeps getting in contempt for not paying child support. I believe he's done time in jail for not paying child support, and he shows up and he cries and he says, I've already paid it with my magic trust. When they go to pick him up, I believe when they go to pick him up off a warrant, they find him with coke. And most people would be kind of ashamed of themselves. Hey, I haven't paid any child support, but I've got the cash to have some coke. That kind of looks bad, right? Most people would be a little embarrassed. What does this guy do? He shows up and says, oh, no, I've resolved this with my magic trust again. So the judge is just like, no, you didn't. No, you didn't. And then sets it for trial. If the trial goes, I kind of want to see it. I really do. I want to know if he's going to stick with this, if he's going to go down with the ship and continue the SovCit thing through trial, or if he's going to go, ironically, like our who is it? Chief Firewater or Captain Firewater or whatever the hell I called him, who finally on the eve of trial said, "Okay, this is nonsense." That was in front of Gauthier. That was a good one. I got a playlist for that too. Chief Firewater pulled this crap for like 2 years. Drunk on his boat. And then right before trial said, oh, okay. My defenses suck. Which they did. And at that moment, like, I thought, okay, fine. It was really stupid, but like I let it go. Good. If you're learning and moving on, good for you, sir. We'll see if this guy, I don't know. This is pretty irredeemable. I haven't paid a cent in child support, but I get caught with illegal drugs, specifically because I wasn't paying child support. And then I just continue with my mantra that I've paid it with my magic trust. But that SovCit's for you. All right. Thanks for coming out. I'll see you soon.